This series of webinars aims to help you advise your clients around housing issues that may arise for them after the UK leaves the EU. This video will take you through helping European nationals apply for housing and homelessness assistance. If you still have questions after watching this, you can contact Housing Rights Helpline on 028 90 245 640. In under 10 minutes, this video will give you an overview of the settlement scheme. It will look again at what is settled and pre-settled status. It will look at defining genuine and effective work and how to help EEA nationals no longer working. It will cover family members of EEA nationals and what emergency help is available for EEA nationals and the eligibility test. The process for applying for social housing will remain much the same way it was before Brexit. European nationals can only apply for housing if they are eligible to do so. However, the new EU settlement scheme could make it easier for some EU nationals to show that they are eligible to apply. The first video in this series covered the EU settlement scheme, so if you need a refresher, we recommend going back to view it. EEA nationals and their dependents can apply for a new type of immigration status under the EU settlement scheme. On applying, a person will be given either settled status or pre-settled status. Settled status is a type of indefinite leave to enter or remain in the UK. Pre-settled status is a form of temporary leave to remain in the UK. A person who has settled status under the settlement scheme has the same rights to access housing and homelessness help as a British or Irish person. This means that they are entitled to this assistance as long as they are habitually resident. A person with pre-settled status will have to go through extra checks to make sure that they are eligible for housing and homelessness assistance. They may be allowed to apply if they are working or if they have previously worked in the UK but are currently unable to do so. They could also apply if they are the family member of a worker or former worker. An EEA national who is working or who is self-employed in Northern Ireland is eligible for housing and homelessness assistance as long as that work is genuine and effective. It is important to understand what will be viewed as genuine and effective work. The government has to believe that a person is really working. Work will be seen as genuine and effective if a person gets paid enough to make national insurance contributions. This is the equivalent of working 24 hours a week at the national minimum wage. If a person earns less than this, it is possible that their work is genuine and effective, but they may need help making this argument. Advisors at Housing Rights can help you find case law and legal arguments to support your case if you are advising clients on this issue. In certain circumstances, a person can be treated as a worker in the eyes of the law even if they've stopped work. A person who has stopped working may still be eligible for housing and homelessness help. They might be eligible if they can't work at the minute because they are pregnant or sick, or if they had an accident but plan to start working again when able to. Or if they had worked in the UK but lost their job and are looking for another job. Or if they lost their job and started vocational training, or if they were self-employed but can no longer run their business because of pregnancy, illness or accident. An EEA national who lost their job and who is currently looking for work can only keep their worker status for a limited amount of time. If they've worked in the UK for less than a year, they can only keep this status for 6 months. If they've worked for more than a year, they will be able to keep this status for 6 months and may be able to keep it for a further 3 months if they can show that there is a good chance of a job offer soon. If an EEA national has had to leave their job or stop self-employment because of pregnancy, they can still get help for up to 1 year after they have stopped working. People from outside the EEA but who are family members of EEA citizens can also access housing and homelessness assistance. These family members will be treated the same as British or Irish people if they have settled status. If they don't have settled status or have pre-settled status, they will be eligible if they can show that their family member is eligible because he or she should be regarded as a worker or is otherwise entitled to assistance. Get advice if you aren't sure who is regarded as a family member. The housing executive must provide temporary housing to someone who is homeless and vulnerable, regardless of immigration status. A person could be vulnerable if they are responsible for looking after children, have a serious illness or disability, or have other serious issues which mean they are less able to cope with homelessness. The housing executive must check if the homeless person passes all 4 tests for homelessness. One of these is the eligibility test. If a person passes the eligibility test, they will be able to stay in temporary housing while the housing executive checks if they pass the other homelessness tests. If a person is homeless through no fault of their own, eligible for assistance, and has priority need, the housing executive has a legal duty to provide this person and anyone who lives with them with housing. If you would like to learn more about the housing executive homelessness tests, Housing Rights have a 3-hour online training course available at www.housingrights.org.uk. If a person isn't eligible, the housing executive doesn't have any long-term responsibility to help them and can ask them to leave the temporary housing within 28 days. They must be told of this decision in writing. Every person who is told that they are not eligible for homelessness assistance is entitled to have that decision reviewed. The housing executive has powers to allow the person to stay in temporary accommodation until the review and appeal process has ended. Housing Rights can give you advice if you are carrying out an eligibility review for your client. To recap, a person with settled status can apply for social housing. A person with pre-settled status will need to show that they are allowed to apply for social housing. They may be allowed to apply if they are working or if they have previously worked in the UK but are currently unable to do so. They could also apply if they are the family member of a worker or former worker. The housing executive must provide temporary housing to someone who is homeless and vulnerable, regardless of immigration status, while it checks to see if the person passes the homelessness tests. A person has a legal right to a review of a decision that they are not eligible and may be able to stay in temporary housing until that review has ended. If you are trying to help a client and are being told they cannot apply for housing or homelessness help, or you need assistance in challenging a decision, you can contact Housing Rights for advice on 028 90 245 640. Visit housingrights.org.uk to keep informed of issues surrounding Brexit and housing. You will find news articles, our professional resource, The Housing Rights of Migrants Living in Northern Ireland After Brexit, and our series of webinars covering the housing issues that may arise once the UK leaves the EU. Signpost your clients to our public advice website, housingadviceni.org, where there is information specific to an EU national's housing rights after Brexit in 8 European languages, including English. If you would be interested in Housing Rights running an information session for your clients, get in touch. The information presented here is correct as of January 2020. However, there is still some uncertainty around the issues of immigration status. Follow us on Twitter or Facebook, or check back regularly to housingadviceni.org to make sure you are up to date on the issues that Brexit may have on your client and their housing situation.